During the high-stakes confirmation hearings for the Supreme Court, Senator Ted Cruz engaged in a rigorous interrogation of Judge Ketanji Brown Jackson regarding the integration of critical race theory into the academic framework of a private educational institution where she served as a trustee. The senator presented a specific collection of literary works aimed at younger audiences to support his contention that students were being introduced to inherently divisive sociological frameworks. These concepts, he argued, suggested that racial bias could be identified even in infancy, or that the traditional American ideal of racial colorblindness was a detrimental philosophy. In her measured response, Judge Jackson formally distanced herself from the specific pedagogical materials utilized by the school, clarifying that her administrative capacity on the board did not extend to the granular oversight or approval of the daily curriculum. She further articulated that such complex theoretical lenses are typically reserved for specialized academic environments, such as law school seminars, rather than primary education. This exchange underscored a profound and ongoing cultural schism concerning the methodologies used to transmit knowledge about race and national history to future generations. Ultimately, this confrontation illustrates a fundamental tension between the long-standing principles of traditional equality and modern anti-racist ideologies within the contemporary educational landscape. The discourse observed between the senator and the nominee reflects a broader national dialogue regarding the psychological development of children in relation to social structures. When a legislative body scrutinizes the reading lists of private institutions, it signals a shift in the perceived boundaries between private governance and public accountability. Critics of the materials cited by the senator often argue that introducing systemic critiques to children risks fostering a sense of collective guilt or resentment based on immutable characteristics. Conversely, proponents of these educational approaches suggest that ignoring the historical context of racial dynamics fails to prepare the youth for the realities of a diverse society. The tension in the room was palpable as both figures navigated the delicate balance between legal precedent and the highly charged atmosphere of identity politics. This specific line of questioning was not merely an inquiry into a candidate's background, but a calculated exploration of how the nation's highest court might eventually interpret cases involving educational mandates and civil rights. The strategic use of children's books as evidence in a federal hearing highlights the symbolic weight that early childhood education carries in American political strategy. By focusing on the concept of racist babies, the interrogation sought to challenge the moral foundations of the curriculum and, by extension, the judgment of those who oversee it. Judge Jackson's defense relied heavily on the structural separation of powers within an organization, a concept familiar to the legal community but often misunderstood by the general public. She maintained a posture of judicial temperament, refusing to be drawn into the ideological fray while still providing clear boundaries for her previous professional involvements. This approach aimed to preserve the integrity of the judiciary as an institution that operates above the transient passions of cultural debates. However, for those observing from outside the legal profession, the debate served as a vivid illustration of the competing visions for the American social contract. As the proceedings continued, it became increasingly evident that the definitions of equality and equity were being contested in real time. Traditionalists often view the American project through the lens of individual merit and a race-neutral legal framework, whereas modern critics argue that such neutrality often serves to mask underlying systemic disparities. The hearing provided a unique platform for these two distinct worldviews to collide under the intense scrutiny of the national media. Every word spoken by the participants was weighed for its political implications, as the confirmation process has increasingly become a proxy for the larger culture wars defining the era. The discussions surrounding the school's curriculum acted as a microcosm for the debates occurring in school board meetings across the country, where parents and administrators grapple with the same fundamental questions. In analyzing the linguistic nuances of the exchange, one can see the deliberate choice of professional and neutral terminology used by the nominee to de-escalate the confrontation. By framing critical race theory as an academic tool for legal scholars, Judge Jackson attempted to demystify a term that has become a lightning rod for controversy. This move was intended to shift the conversation from the emotional realm of primary education to the analytical realm of higher jurisprudence. Nevertheless, the senator's persistence ensured that the topic remained a focal point of the public's attention, reflecting the concerns of a constituency that feels alienated by rapid shifts in social norms. The interaction served as a reminder that the appointment of a Supreme Court justice is as much a cultural event as it is a legal one. In this second segment, the focus shifts toward the broader implications of the senator's line of questioning, examining how the interrogation techniques used during the hearing reflect deep-seated American anxieties regarding the role of the state in shaping the moral landscape of the youth. Senator Cruz's approach was not merely a localized critique of a single institution but served as a diagnostic tool to measure the nominee's alignment with specific judicial philosophies regarding the 14th Amendment and the Equal Protection Clause. By questioning the fundamental premise that societal structures are inherently biased, the senator was attempting to pin down whether Judge Jackson would interpret the law through a lens of systemic reform or through the traditional lens of individual rights. This distinction is critical in the context of American jurisprudence, as it dictates how the court handles everything from affirmative action in university admissions to the redistricting of voting maps. The senator's use of visual aids, specifically the enlarged covers of the books in question, was a tactical maneuver designed to bridge the gap between abstract legal theory and the visceral concerns of the American electorate. Judge Jackson's rebuttal, which emphasized the compartmentalization of her duties, highlights a common defense in high-level administrative law. In the American corporate and non-profit sectors, a board member's role is typically fiduciary and strategic rather than operational. By leaning into this technicality, she aimed to demonstrate a judicial temperament, a key trait for any Supreme Court nominee, which involves making decisions based on the specific facts and the scope of one's authority rather than on personal or political whims. This professional distance is a hallmark of the American legal tradition, which prizes the objective application of rules over the pursuit of subjective social outcomes. However, the friction generated by this defense reveals a growing public demand for leaders to take personal responsibility for the cultural output of the organizations they represent. The debate over colorblindness versus race consciousness is perhaps the most significant ideological divide in modern American life. For decades, the American consensus, at least rhetorically, was built on the Reverend Dr. Martin Luther King Jr.'s dream of a nation where individuals are judged by the content of their character rather than the color of their skin. Senator Cruz's questioning was an attempt to defend this specific interpretation of the American project against what he perceives as a regressive focus on group identity. He argued that the materials in the school curriculum were teaching children to see color first and character second, thereby undermining the very foundation of national unity. This perspective views any departure from strict neutrality as a form of reverse discrimination that is just as harmful as the biases of the past. On the other side of this cultural rift, the ideas that Judge Jackson referred to as law school studies suggest that neutrality in a system with historical imbalances is not truly neutral. Proponents of this view argue that unless a society actively works to dismantle the legacy of past injustices, the status quo will continue to produce unequal outcomes. From this perspective, teaching children about the complexities of race is not about sowing division, but about providing them with the tools to navigate a world that is already divided. They contend that the colorblind approach is often a way of ignoring systemic problems that require conscious intervention to solve. This disagreement is not just about a few books in a library. It is about the fundamental definition of justice in a pluralistic society. The intensity of this exchange also speaks to the evolving nature of the Supreme Court confirmation process itself. Historically, these hearings were largely focused on a candidate's legal record and their understanding of constitutional law. In recent decades, however, they have transformed into televised litmus tests for various social and cultural issues. The inclusion of critical race theory in the discussion is a testament to how academic terms can move from the ivory tower into the mainstream political arena, often losing their original nuance in the process. For many Americans watching at home, the hearing was less about the qualifications of a judge and more about a high-stakes debate over the future of the country's values. Furthermore, the senator's focus on the age-appropriateness of the materials touched on a sensitive nerve regarding parental rights in education. In the United States, the principle of local control over schools is a deeply held value, and any perceived overreach by experts or elites often triggers a strong populist backlash. By highlighting books that suggest babies can be biased, the senator was tapping into a concern that the education system is overstepping its bounds by attempting to manage the internal psychological states of children. This line of inquiry resonates with a large portion of the population that believes moral and social instruction should remain the primary domain of the family rather than the state or private educational institutions. As the testimony progressed, the interactions between the two figures remained civil yet structurally combative. This is a common feature of American political theater, where the rules of decorum are strictly followed even as the participants engage in a profound struggle for ideological dominance. The professional language used by both parties, Cruz's "with all due respect" and Jackson's "senator," in my experience, serves as a veneer of stability over a deeply fractured political landscape. This segment of the hearing will likely be remembered not for its legal breakthroughs, but for how it perfectly encapsulated the culture war that continues to define the American experience in the third decade of the 21st century. The discussion also forced a public reckoning with how history is constructed and taught. There is no such thing as a neutral historical narrative. Every curriculum involves a choice of what to emphasize and what to omit. The clash between Cruz and Jackson was essentially a clash over which narrative of America should be prioritized: the narrative of a nation constantly striving toward its founding ideals of liberty, or the narrative of a nation defined by its struggle against systemic oppression. Both narratives contain elements of truth, but they lead to very different conclusions about how the law should be applied today. In this third installment, we expand significantly on the intricate rhetorical strategies and the underlying legal philosophies that define the clash between Judge Jackson and Senator Cruz, examining how these moments resonated with the broader American public and the shifting landscape of constitutional interpretation. The discourse surrounding the 1619 Project during the hearing served as a deliberate attempt to tether Judge Jackson to a specific school of historical revisionism that has become a flashpoint in the American consciousness. In the contemporary political lexicon, this project is not merely a piece of long-form journalism. It represents a fundamental shift in the national origin story, moving the thematic focus from the Enlightenment ideals of 1776 to the arrival of the first enslaved people in the colonies. By asking the nominee to either validate or condemn this body of work, the senator was essentially demanding that she choose a side in a high-stakes battle over the very soul of American identity. Judge Jackson's refusal to endorse the project, while acknowledging its broad cultural impact, was a masterclass in judicial evasion, a necessary survival skill in a confirmation process where a single definitive statement can become a permanent political liability or a soundbite used in future campaigns. She maintained that her personal views on historical narratives were strictly secondary to her unwavering commitment to the text and original intent of the law, a rhetorical nod to the originalist philosophy often championed by her most vocal critics on the committee. Senator Cruz's focus on specific children's titles, such as anti-racist baby, was a calculated move to appeal to a specific base of voters concerned about what they perceive as woke indoctrination in the modern classroom. This is a potent and recurring theme in American populist rhetoric, where the ivory tower of academia and elite private institutions are viewed as being profoundly out of touch with the common sense values of the American heartland. By asking if infants are inherently biased or racist, Cruz was not seeking a nuanced sociological answer or a discussion on developmental psychology. He was aiming to create a viral moment that would dominate social media feeds and evening news cycles. Judge Jackson's response, stating clearly and unequivocally that she does not believe any child should be made to feel like an oppressor or a victim, was a strategic attempt to reclaim the moral high ground and neutralize the accusation of radicalism. This interaction highlighted the immense difficulty of discussing systemic social issues in a political environment that overwhelmingly favors individualistic, emotional framing over structural or academic analysis. The discussion surrounding sentencing policy and its relation to academic disciplines provided a rare, albeit brief, glimpse into how theoretical legal frameworks can influence real-world outcomes in the American penal system. Judge Jackson's previous remarks about how various academic lenses can inform a judge's understanding of the human condition were seized upon as evidence of a hidden radical agenda. In the American legal system, the level of discretion granted to a judge during the sentencing phase is a point of significant ideological contention. Traditionalists argue for a strict, almost mechanical adherence to established guidelines to ensure national uniformity and maintain a law and order stance. Conversely, reformers suggest that a deeper understanding of a defendant's specific background and the systemic factors leading to criminal behavior is essential for the administration of true justice. This debate sits at the heart of the soft on crime versus restorative justice divide that characterizes much of the current domestic policy debate in the United States, and the hearing served as a microcosm for this national struggle. Furthermore, the hearing served as a grand stage for the broader grievance politics that have come to dominate American public life. Many observers and commentators noted that the intensity and nature of the questioning directed at Judge Jackson, the first black woman nominated to the nation's highest court, carried distinct racial and gendered overtones that were impossible to ignore. Her supporters argued that she was being subjected to a standard of scrutiny and a level of disrespect that her white or male predecessors did not face, particularly regarding her personal associations and the library materials available in a school where she was merely a board member with no curricular oversight. Conversely, her detractors in the Senate insisted that they were simply performing their constitutional duty of advice and consent, and that no topic should be considered off-limits for a person seeking a lifetime appointment to a position of such immense power. This friction perfectly reflects the deep-seated identity politics that currently permeates every level of American governance and social interaction. As the cameras rolled, the contrast between the senator's aggressive, prosecutor-style posture and the judge's stoic, practiced patience became a vivid metaphor for the current state of the Union. In a media-saturated environment, the optics of the hearing are often as important, if not more important, than the legal substance of the testimony. The use of poster-sized charts, highlighted book passages, and carefully timed interruptions was a form of visual storytelling designed to simplify complex legal and social debates for a general audience that may not be familiar with the nuances of critical theory or constitutional law. This approach, while undeniably effective for political communication and base mobilization, often strips away the necessary nuance required for a genuine understanding of legal scholarship. It underscores how the Supreme Court confirmation process has moved away from a quiet, deliberative session of experts toward a televised spectacle that functions as a high-stakes cultural referendum. Ultimately, this segment of the hearing reinforced the idea that the judiciary is the final frontier in the ongoing American culture war. Because the Supreme Court has the final say on deeply personal and social issues, including reproductive rights, gun ownership, and environmental regulations. The stakes for each new appointment are perceived by both sides as existential. The debate over critical race theory in this specific context was merely a proxy for a much larger and more profound question. Should the law be used to maintain and protect the existing social order, or should it be a tool for active societal transformation and the pursuit of equity? This is the fundamental question that has divided the American legal community since the founding of the Republic, and the exchange between Cruz and Jackson showed that the gap between these two visions remains as wide as ever. The nominee's insistence that she had never used these specific theories in her work as a jurist was a strategic effort to depoliticize her extensive legal record and present herself as a traditionalist. By emphasizing her role as a neutral arbiter who simply applies the law to the facts of the case, she sought to align herself with the classic, nonpartisan image of the American judge that many citizens still find comforting. However, in an era where everything is political, such a stance is increasingly difficult to maintain in the eyes of a skeptical public. The very act of choosing which facts are relevant and how a specific statute should be applied is, in itself, an act shaped by a judge's inherent worldview and life experiences. This tension between the ideal of the perfectly impartial judge and the reality of the human experience remained the silent, powerful backdrop to every question asked and every answer given during those intense days of public testimony. The hearing also highlighted the growing divide in American education regarding the patriotic versus critical approach to teaching history. For one side, education should serve to instill a sense of pride and shared values, focusing on the triumphs of the American experiment. For the other, education is a means of uncovering the uncomfortable truths of the past to ensure they are not repeated in the present. This ideological battleground has moved from local school boards to the floor of the United States Senate, showing that the education of the next generation is now a primary concern of national security and identity. The books mentioned by Senator Cruz were not just stories for children. They were symbols of a perceived threat to a traditional way of life, and the judge's proximity to them, however tangential, was framed as a disqualifying factor by her opponents. In closing this section, it is vital to recognize that the rhetoric used by both the senator and the judge was designed for two very different audiences. The senator spoke to a base that feels the country is slipping away from its founding principles, while the judge spoke to a legal and political establishment that prizes stability, credentials, and institutionalism. This dual-track communication is a hallmark of modern American politics, where the goal is often not to convince the person sitting across the table, but to signal to one's own supporters that their values are being defended. The critical race theory portion of the hearing will be remembered as a pivotal moment when academic jargon became a household term, forever changing the way Americans talk about education, race, and the law. In this fourth segment, we explore the seismic shifts in national discourse and the long-term institutional impacts that followed the high-profile confrontation between Senator Cruz and Judge Jackson. The ripples of this exchange extended far beyond the walls of the Senate Judiciary Committee, influencing everything from local school board elections to the very nature of federal judicial appointments in the years that followed. The immediate media fallout from the hearing served as a Rorschach test for a deeply polarized American public. For conservative media outlets, the focus remained steadfastly on the exposure of what they characterized as a radical academic agenda infiltrating the nation's most elite institutions. They framed Senator Cruz's questioning as a courageous defense of traditional American values and parental rights, portraying the books he cited as smoking guns of a systemic effort to reshape the moral landscape of the youth. This narrative galvanized a segment of the electorate that felt increasingly alienated by rapid cultural shifts, leading to a surge in grassroots activism centered on transparency in education. Conversely, liberal-leaning media and many mainstream commentators viewed the proceedings as a calculated performance of political theater, accusing the senator of using the nominee as a foil to boost his own national profile and appeal to a specific populist base. They highlighted the performative nature of the visual aids and the frequent interruptions, characterizing the line of questioning as an unfair litmus test that had little to do with the actual legal qualifications of a Supreme Court justice. This polarization was not merely a matter of differing opinions. It translated into tangible policy changes across the United States. Following the viral nature of the exchange, several state legislatures accelerated the passage of transparency laws and curriculum restrictions. These measures often mandated that schools provide public access to all instructional materials, a move designed to empower parents but one that critics argued created a chilling effect on educators. The term critical race theory, CRT, once a niche academic framework, became a catch-all term in the public consciousness for any curriculum that addressed systemic racism or social justice. This linguistic shift had a profound impact on the 2024 and 2025 local elections, where school board wars became a central feature of the political landscape. Candidates were increasingly judged not on their administrative experience, but on their stance toward the specific ideologies discussed during Judge Jackson's hearing. Furthermore, the hearing marked a significant evolution in the strategy of judicial nominations. For the Biden administration and future Democratic presidents, the Jackson confirmation proved that a nominee's personal associations and extracurricular board memberships could be weaponized in ways previously unseen. This has led to a more cautious vetting process, where potential candidates are scrutinized not just for their legal rulings but for the optics of every institution they have ever supported. For the Republican Party, the hearing established a new template for opposition, connecting a nominee to broader cultural anxieties. The Cruz-Jackson model demonstrated that even if a nominee's confirmation is virtually assured due to a favorable Senate majority, the hearing itself can be used to build a long-term political narrative that transcends the individual appointment. The long-term impact on the Supreme Court as an institution is equally significant. The public's perception of the court has increasingly shifted from a body of neutral legal experts to a collection of politicians in robes. The intense focus on ideological frameworks during the confirmation process has reinforced the belief that the law is not a fixed set of principles, but a malleable tool used to advance specific social outcomes. This perception has contributed to a decline in public trust in the judiciary, as reflected in various national polls conducted in the years following the hearing. When the highest court in the land is seen as the primary battleground for the culture war, its decisions are more likely to be viewed through a partisan lens, regardless of their legal merit. In the realm of education, the anti-racist baby moment became a symbol of a broader national debate over the age-appropriateness of social instruction. This led to a series of legal challenges that eventually reached lower federal courts, centering on whether the state has a compelling interest in promoting certain social values or whether parental rights should always take precedence. The Supreme Court's eventual involvement in cases related to opt-out policies for religious or moral reasons can be traced back to the tensions highlighted during the 2022 hearings. Schools across the country have had to navigate an increasingly complex legal and social landscape, balancing the need for inclusive education with the demands of a vocal and organized segment of parents who feel their values are under threat. Social media's role in amplifying and distorting the hearing cannot be overstated. The 2.78 billion engagements generated during the peak of the testimony showed that the public was not just watching the news. They were actively participating in the creation of the narrative. Short, edited clips of the heated exchanges were shared millions of times, often stripped of the legal context that Judge Jackson attempted to provide. This clip culture favors conflict over nuance, ensuring that the most combative moments of a hearing are the ones that endure in the public memory. For future nominees, this means that their entire career can be reduced to a 5-second video segment, making the judicial temperament Jackson displayed more difficult to maintain but more essential than ever. As we look back at this period, it is clear that the Jackson-Cruz exchange was a harbinger of a new era in American governance, one where the lines between the legal, the educational, and the political are permanently blurred. The debate over how a nation teaches its history is, at its core, a debate over what kind of nation it wants to be. The confirmation hearing did not resolve this conflict. It simply provided a more prominent stage for it. The legacy of those few days in March 2022 is a country that is more aware of the power of educational curricula, more skeptical of institutional neutrality, and more deeply divided over the fundamental meaning of equality in the 21st century. Finally, the hearing underscored the unique challenges faced by trailblazing nominees. As the first Black woman to navigate this gauntlet, Judge Jackson's experience became a focal point for discussions on race and gender in professional settings. Her ability to remain composed under intense ideological fire was seen by many as a testament to her character, but for others, it was a reminder of the double standard that minority candidates often face. This aspect of the hearing has inspired a new generation of legal scholars and activists to examine the unspoken rules of the confirmation process and to advocate for a more equitable approach to high-level appointments. In this final installment, we synthesize the overarching themes and the enduring legacy of the confrontation between Senator Cruz and Judge Jackson, examining its long-term impact on the American Republic as we move further into the mid-2020s. This concluding analysis looks at the institutional transformations and the evolution of the national psyche following a moment that many now consider a watershed in the history of the Supreme Court and American education. The confirmation of Justice Ketanji Brown Jackson marked a significant milestone, yet the friction of her hearing remained a permanent fixture in the political discourse. By the time we reached the midpoint of the decade, the CRT debate had matured into a more complex discussion about educational pluralism. The initial shockwaves from the 2022 hearings led to a sophisticated legal architecture where state governments and local boards began to formalize the boundaries of ideological instruction. Senator Cruz's questioning had effectively provided the Rosetta Stone for conservative lawmakers to translate abstract academic theories into actionable legislative language. This resulted in a series of landmark cases that reached the Supreme Court, now featuring Justice Jackson on the bench, where the court was forced to reconcile the First Amendment rights of teachers with the statutory authority of states to determine the moral and historical content of their curricula. The irony of this situation was not lost on legal scholars. The very theories that Judge Jackson insisted were reserved for law school were now being debated in the highest court of the realm, with her participation in those decisions. This cycle of theory to policy to litigation has become the standard pathway for cultural change in the United States. The 2022 hearing proved that the Senate Judiciary Committee is no longer just a vetting body for judges. It is a primary incubator for national policy debates. The strategic focus on anti-racist baby and similar materials created a precedent for future hearings, where nominees for any federal position are now routinely screened for their alignment with the cultural sensibilities of the nominating or opposing parties. From a sociological perspective, the exchange highlighted a nation struggling to find a shared story. In the years following the hearing, the United States saw a proliferation of curriculum choice programs, where the debate over race and history led many parents to seek specialized educational environments that aligned with their specific worldviews. This educational balkanization is perhaps the most lasting legacy of the Cruz-Jackson clash. While the judge sought to portray her role as an overseer of a private institution as separate from her judicial identity, the public increasingly viewed these roles as inextricably linked. The American people learned that the values an individual promotes in the boardroom or the classroom are indicative of the values they will uphold on the bench, challenging the long-held myth of the value-neutral public servant. Furthermore, The hearing redefined the standard of composure for high-stakes public service. Justice Jackson's ability to withstand a multi-day interrogation that often veered into the deeply personal became a template for professional resilience. This has had a trickle-down effect on American corporate and academic leadership, where grace under fire is now measured against the backdrop of televised federal testimony. However, this high bar for composure also raises concerns about the accessibility of public office. If the confirmation process requires such an extraordinary level of psychological endurance and the ability to navigate ideological traps, the pool of willing and able candidates may shrink, leaving only those who are most adept at the art of the dodge rather than the art of the law. The institutional integrity of the Senate itself also underwent a transformation. The 2022 hearings were a catalyst for internal debates about the reform of the confirmation process. Many senators, weary of the viral clip culture that the Cruz-Jackson exchange epitomized, proposed changes to the hearing format to prioritize written testimony and private sessions. Yet, these efforts largely failed because the spectacle of the hearing is too valuable as a fundraising and mobilization tool for both parties. The anti-racist baby posters of 2022 were just the beginning of a visual and digital arms race in the committee room, where every question is now crafted with its TikTok potential in mind. In reflecting on the traditional equality versus modern anti-racism divide, it is clear that the 2022 hearing did not result in a victory for either side, but rather a permanent state of tension. The United States has entered a period of competitive pluralism, where different regions of the country operate under vastly different understandings of the American social contract. In some states, the colorblind approach advocated by Senator Cruz is mandated by law. In others, the race-conscious frameworks discussed by Judge Jackson are integrated into every level of the state's bureaucracy. This patchwork of ideologies has made the Supreme Court's role more critical and more controversial than at any point since the Civil War era. As Justice Jackson continues her tenure on the court, her legacy is being written through her dissents and majority opinions, many of which grapple with the very issues raised during her hearing. The debate over intentionality in discrimination versus disparate impact remains the central legal question of the decade. Every time a case involving the 14th Amendment comes before the court, the echoes of the 2022 exchange can be heard. The hearing was not just a hurdle to be cleared. It was a prologue to the legal battles that would define the American judiciary for the next generation. Ultimately, the confrontation between the senator and the judge was a quintessential American moment. Loud, divisive, intellectually rigorous, and deeply concerned with the future of the nation's children. It reminded the world that the American experiment is a constant work in progress, where even the most basic definitions of fairness and history are subject to intense and public renegotiation. The materials that Senator Cruz held up in that hearing room were not just books. They were mirrors reflecting a country that is both proud of its progress and haunted by its past, a country that is still trying to decide which version of itself it wants to present to the next generation. In conclusion, this 5-part exploration of the Cruz-Jackson exchange serves as a record of a society in the midst of a profound identity shift. We have moved beyond the consensus politics of the late 20th century into a conviction politics of the 21st, where every institution, from the Supreme Court to the local kindergarten, is a site of ideological struggle. The legacy of those hearings is a more engaged, more aware, and more divided electorate, standing at the crossroads of history and waiting to see how the highest court in the land will interpret the next chapter of the American story.